Thank you very much, Chair. I would like to provide an update now on relativity. During my opening statement in November, I explained that the inquiry procured relativity as its document review platform, and that it would be used for document management and for internal purposes during our disclosure processes. Legal representatives have not needed access to relativity in order to engage with our disclosure processes. The inquiry is now using relativity to review documents. Relativity enables the inquiry to tag documents for themes and issues and easily collate material for witnesses and for disclosure. The inquiry will keep under review whether or not relativity is to be used more widely. For example, whether limited access should be granted to core participants and their representatives as a means by which to receive and review material disclosed by the inquiry. I'd like now to talk about this hearing, which runs from today up to the 15th of May. The first point to make is that the evidence we will be hearing is introductory. The purpose of this hearing is to introduce important contextual evidence relating to the provision of mental health inpatient care in Essex, and to explore some specific issues concerning the provision of care. In other words, this hearing is setting the scene for the work of the inquiry and the hearings that will come later. And that's a point you've already made, Chair. The second point relates to the status of the written witness statements that have been provided for this hearing. This includes from healthcare providers. The witness statements stand as the evidence from the particular individuals giving them or the organisations on whose part they have been provided. The inclusion of these statements in the written evidence for this hearing does not mean that the inquiry accepts that they are accurate in all regards. In some cases, we already know of inaccuracies. And this evidence will, of course, be augmented by the oral evidence we will be hearing and the points made at a later stage, including in later hearings. The third and final preliminary point is this. We are at an early stage in an inquisitorial process. Core participants and their lawyers are not, at this stage, committing themselves to a particular stance by suggesting questions to the counsel team to be asked, by making submissions, or in any other way. It may be that as more evidence is provided, different points will emerge, and the points they and the inquiry wish to advance will involve or change completely. New points will inevitably arise. That is understood. At this hearing, we are setting the foundations for the evidence to follow, and core participants and their lawyers will have the opportunity in the future to revisit the issues raised. Moving now to the timetable. The inquiry will sit on Mondays to Thursdays during the hearing, however will not sit on bank holiday Monday the 5th of May, nor on Wednesday the 7th of May. We'll generally start our hearings at 10 a.m. and finish by 4:30 p.m. There'll be a short break in the morning and in the afternoon, in which teas and coffees will be provided free of charge for those who are attending. There'll be a 1-hour break for lunch, which will normally be at around 1 to 2 o'clock. Chair, we'll be flexible with all of our timings, as is appropriate for an inquiry of this nature. Our hearings are taking place here at Arundel House in London. The hearing room we are now in has been deliberately laid out to allow the families, those with lived experience, and others engaging with the inquiry to sit at the front. Lawyers have been provided with desks equipped with appropriate technology, situated at the back of the room. It's not necessary to attend the hearing in person to follow the inquiry's proceedings. Court participants and their lawyers who are not attending in person can watch the hearing live on a secure web link. The hearing will also be live streamed on the Lampard Inquiry YouTube channel for anyone who wishes to watch us remotely. But please note that this will be streamed with a time delay of 10 minutes. So if you're watching on YouTube, there will be a 10-minute delay. The inquiry will be considering different forms of evidence at this hearing. It breaks down into the following broad categories. First, we have the written evidence. This is in the form of the witness statements, exhibits to those statements, and reports. They form part of the inquiry's body of evidence to which you, Chair, will have regard in reaching conclusions and considering recommendations. Certain evidence is being summarised and synthesised in papers that will be presented at this hearing by members of the Counsel to the Inquiry team. Core participant legal representatives have been given the opportunity to comment on these papers in writing, with counsel for the family core participants being given the opportunity to respond in oral presentations to you, Chair. I should add that the counsel team will provide some further brief summaries during the hearing of a couple of other areas covered by the written evidence, and these won't be subject to the same process of response by the core participant teams. We will also be seeing evidence in the form of video footage, and we will, of course, be hearing evidence directly from certain witnesses. Whilst witnesses will be asked questions by counsel to the inquiry on behalf of the Chair, those questions will have been informed by suggestions provided by the core participants. This approach is covered by the inquiry's protocol on the questioning of witnesses in oral hearings under Rule 10 of the inquiry rules. Chair, you will also ask questions yourself as you feel appropriate. For those family core participants who are unrepresented, I invited them to meet with me and other members of the inquiry team informally following receipt of the bundles for this hearing. This was with a view to them raising any points that they would like to be considered with the witnesses, and that meeting took place earlier this month. Chair, I would like now to provide an introduction to the evidence that will be presented at this hearing. A schedule of the witnesses that you'll be hearing from will be available on the inquiry website, and we've divided the topics to be covered into different categories. The first category is, significantly, some of the issues of concern that led to this inquiry. On the 10th of October 2022, Channel 4 broadcast a Dispatches documentary entitled Hospital Undercover, Are They Safe? The programme showed footage from a year-long undercover investigation and highlighted concerning practices on various wards run by EPIRT. It's an important piece of reporting. It covers issues of great relevance to this inquiry, including concerning ligatures, the behaviour of those working on the unit, the use of restraint, and absconding from wards. We will be showing this tomorrow. Chair, the inquiry is working with the producers of the documentary to obtain further unaired footage which may be relevant. Staying with issues of concern that led to the inquiry, I come now to the Health and Safety Executive's prosecution of EPIRT in 2020. I may refer to the Health and Safety Executive as the HSE. It concerned failures between the 1st of October 2004 and the 31st of March 2015 in relation to ligatures and the tragic deaths of 11 patients at the North Essex Partnership University Trust, a predecessor trust to EPIRT, and which I'll refer to as NEPT. The HSE prosecution began as an investigation by Essex Police in 2016. In 2018, that investigation was formally handed over to the HSE. As I mentioned in September last year, the outcome of that case was that EPIRT pleaded guilty on the 20th of November 2020 to a charge that it had failed, as far as was reasonably practicable, to manage the environmental risks from fixed ligature points within its inpatient mental health wards across various sites under its control, thereby exposing vulnerable patients in its care to the risk of harm by ligature. EPUT received a fine of £1.5 million during sentencing on the 16th of June 2021. In 2014, NEPT had also been investigated and prosecuted following failures at the Derwent Centre in Harlow, where a patient fell from a window that was not adequately restricted. These are the only two prosecutions of any kind of providers of mental health care in Essex that the inquiry is currently aware of during the relevant period. The inquiry has received and disclosed to core participants the witness statement of EPUT CEO Paul Scott, which addresses these prosecutions. The inquiry will be hearing from the HSE's Director of Regulation, Jane Lassie. She will explain how the HSE works in partnership with co-regulators to inspect, investigate, and where necessary to take enforcement action. The HSE is the national independent regulator for health and safety in the workplace. This includes private or publicly owned health and social care settings in Great Britain. As an HSE publication explains, there are many other bodies responsible for regulating different aspects of health and social care. They may be in a better position to respond to patient incidents or complaints. In England, the CQC is the independent regulator for the quality and safety of care. This includes the care provided by the NHS, local authorities, independent providers, and voluntary organisations in registered settings. They are also professional regulatory bodies who aim to ensure proper standards are maintained by health and social care professionals and act when they are not. Ms. Lassie will explain where the HSE fits in this picture. At this stage, it's helpful to look at two of the slides provided with the King's Fund presentation. And Amanda, would you put up slide 23, please? I've already mentioned the presentation provided by the King's Fund, and here we see one of the slides. And we can see in the slide reference to the Health and Safety Executive and other regulators I've referred to. And they include the Parliamentary and Health Service Ombudsman. I'll come on to talk about him in a moment. Thank you. Would you take that slide down, please, and put up slide 22. So the former slide was non-NHS regulatory and investigatory bodies, and here we see NHS regulatory and investigatory bodies. We can see the CQC at the bottom, as well as bodies such as the Health Services Safety Investigations Body. Overall, it's quite a crowded picture, and it's not clear how everyone fits in. Would you take that down, please? Consequently, the inquiry is interested in the multiplicity of regulators and other relevant bodies operating within the sector. Questions arising may include, to what extent were there uncertainties about jurisdiction between these various bodies? Did some incidents fall through the gaps between them? And what certainty do we have now that inpatient deaths are always being properly investigated and, where necessary, prosecuted? In June 2019, Sir Rob Berens, CBE, who was then the PHSO, published his report entitled Missed Opportunities. It found that there had been a series of significant failings in the care and treatment of 2 vulnerable young men who died shortly after being admitted to NEPT. The report considered the death in 2008 of a person referred to as Mr. R, and the death in November 2012 of Matthew Leahy. It identified multiple failings surrounding both deaths. The report also identified systemic issues at the Trust, including a failure over many years to develop the learning culture necessary to prevent similar mistakes from being repeated. Sir Rob was PHSO, the Ombudsman, from 2017 to last year, and we'll be hearing from him on a range of matters. As I've said, this includes the deaths of Mr. R and Matthew Leahy. These are cases that the inquiry will be considering in more detail at a later hearing. But I will ask Sir Rob about some aspects of these cases at this hearing arising from the Missed Opportunities report. Whilst he was not Ombudsman at the time of the investigation and investigation report into Mr. R's case, Sir Rob oversaw Miss Leahy's complaint about her son Matthew from 2017 to 2019. We will hear about the maladministration that was exposed at NEPT. There were 19 different instances. These included in relation to care planning, risk assessment, and the physical availability of ligatures. They also included the failure properly to look after Matthew's physical care and the loss and falsification of paperwork. We will also learn about the role of the PHSO, its processes, and the extent of its powers. The PHSO considers complaints about care and treatment commissioned or delivered by the NHS in England. Broadly speaking, a complaint about a mental health trust is probably within the PHSO's jurisdiction. We'll need to understand where the PHSO fits into the complex picture of the bodies and regulators that look into the serious problems with which we are concerned. As we've just seen, other organisations consider different types of complaints. It's important also to know that the PHSO can only look into issues that have been complained about. That means that it cannot act of its own motion. It is also a point of last resort in that a person has to try to resolve their case by other available means first. Sir Rob will provide figures for complaints received relating to mental health and complaints relating specifically to EPUT and its predecessor trusts, NEPT and the South Essex Partnership University Trust, or SEPT, and NELFT. We will look at those figures and see what we can learn from them. The inquiry has received a number of statements from the regulators and other relevant bodies. They will form part of the inquiry's body of evidence, and the most relevant parts of this evidence will be summarised for you, Chair. Evidence has been received from the bodies who regulate the individual professions, who together have provided the mental health inpatient care subject to this inquiry. Those bodies, as we've just seen from the King's Fund slide, are the General Medical Council, who regulate doctors, including psychiatrists, the Nursing and Midwifery Council, who regulate nurses and mental health nurses, and the Health and Care Professionals Council, who regulate a number of professionals, including practitioner psychologists and occupational therapists. Collectively, I will refer to these as the healthcare professional regulators. Although responsible for different professions, the way in which they operate and the key principles which inform their work are broadly the same. Each seeks to ensure that their professions are safe, for professionals are safe to practice, to declare and uphold their profession standards, and to maintain the public's confidence in their profession. To do this, they will act against individual professionals where concerns are raised and where they are sufficiently serious to call into question their fitness to practice. The ultimate sanction available during these proceedings will be to erase or strike off an individual from that profession's register. it is of note that where there is an alleged failing by a healthcare professional, such a failing must be sufficiently serious in order to merit fitness to practice proceedings. Further, their jurisdiction only extends to their respective individual profession, and they are not designed to deal with cases where failings are said to span a number of professions, or where failings are systemic rather than individual. The inquiry has sought details from each of the healthcare professional regulators of cases against registrants in Essex trusts, which are linked to the provision of mental health inpatient care. Although there have been challenges in obtaining historic data, and it is currently incomplete, initial responses indicate the following. At the GMC, the General Medical Council, a review of cases since the 1st of April 2006 has identified 29 complaints or concerns in respect of doctors. None of these have to date resulted in any action being taken against the registered doctors concerned, although some remain subject to ongoing investigation. A number of cases fell short of the threshold for investigation where concerns were not considered sufficiently serious or were not considered to be directed against an individual doctor, but rather concerned overall care. The NMC, Nursing and Midwifery Council. From materials which it has been possible to review from 2008 onwards, the NMC have identified 149 referrals concerning 133 nurses. 146 received an initial assessment, and this has resulted in 65 cases being closed at initial screening and 81 progressing for further investigation. 36 were referred for a hearing and 29 have concluded. Of those concluded, fitness to practice was found impaired in 24 cases. There have been 4 cautions, 4 orders for conditions of practice, 13 suspensions, and 6 orders for striking off. 24 cases remain open. The HCPC, Health and Care Professionals Council. From the data available from 2003, there have been referrals concerning 12 professionals, 8 psychologists, and 2 occupational therapists. This has resulted in one case where the registrant was voluntarily removed from the register on health grounds, and 11 cases which were closed without referral to fitness to practice proceedings. The information so far underlines the high threshold for taking action against individual healthcare professionals. Some of the available cases illustrate that healthcare professional regulators will not be the appropriate avenue to deal with systemic or low-level but widespread concerns. This perhaps highlights the importance of others being able to manage concerns arising within mental health inpatient care. For present purposes, let me talk about the Care Quality Commission. This is the body which, since 2009, has been responsible for regulating health and adult social care in England. This means that it was responsible for the registration, monitoring, and inspection of the trusts and their mental health inpatient care provision. Its duties included review of these services, assessing their performance, and publishing reports of its assessments. The CQC also describes itself as the primary enforcement body at a national level for ensuring that people using health and social care services receive safe care of the right quality. Fundamental standards introduced following the Mid-Staffordshire NHS Foundation Trust public inquiry, and against which healthcare providers were assessed as part of the CQC's function, are Regulation 9, Person-Centred Care, Regulation 10, Dignity and Respect, Regulation 11, Need for Consent, Regulation 12, Safe Care and Treatment, Regulation 13, Safeguarding Service Users from Abuse and Improper Treatment, Regulation 14, meeting nutritional and hydration needs. Regulation 15, premises and equipment. Regulation 16, receiving and acting on complaints. Regulation 17, good governance. Regulation 18, staffing. Regulation 19, fit and proper persons employed. Regulation 20, duty of candour. And Regulation 28, requirement as to display of performance assessments. Relevant CQC and inspections and the reports which followed will in due course be considered by the inquiry. Recent inspections included the May 2023 assessment, which downgraded the rating of EPUT adult mental health wards and psychiatric care units to inadequate, and a July 2023 report following an inspection between November 2022 and January 2023, which gave EPUT a rating of requires improvement. The CQC has also statutory responsibility under the Mental Health Act 1983 for monitoring and reviewing how services use their powers of detention and in respect of community treatment orders. This ought to include visiting wards and identifying concerns which might trigger further monitoring or inspection. In addition, and distinct to its role in registering and inspecting healthcare providers, the CQC has substantial statutory powers to take both civil and criminal enforcement action against registered persons who fail to comply with conditions of registration and CQC regulations aimed at ensuring safe and adequate care. Civil enforcement powers include cancelling or suspending registration, imposing conditions, or serving a warning notice. Criminal enforcement can also be undertaken by use of a fixed penalty notice, cautions, and prosecutions. The inquiry has been made aware of a warning notice issued to NEPT in 2016. However, set against their considerable responsibilities and powers, it is of note that during the relevant period, there are apparently no other recorded instances of the CQC having used civil or criminal enforcement action against the trusts in Essex, and we'll look into that more deeply. Whilst it is too early to draw any conclusions from the absence of any enforcement action, the inquiry will wish to understand this more fully when set against the extremely serious concerns that gave rise to and are the subject of this inquiry. Chair, I turn now to the topic of ligature and absconsion, incident information and data. I've already highlighted the considerable concern regarding ligature deaths that led to the HSE prosecution. There is also real concern about the risks arising from absconsions. The inquiry asked EPUT, other trusts and private providers for various information and data in respect of ligature and absconsion-related incidents in Essex over the period covered by this inquiry. The purpose of obtaining this information for this April hearing was this: to enable the inquiry to investigate what was happening within these providers in relation to ligature and absconsion incidents during the relevant period. It was also to inform any further lines of investigation and disclosure that the inquiry might wish to seek. The providers responded in varying levels of detail. Not all of the providers responded in time for their evidence to be considered within this April hearing. The evidence that was received by the inquiry by the 27th of March this year, including witness statements and exhibits, has been considered by counsel to the inquiry, who have provided papers covering these matters. Kirsty Lee of the CTI team will present them to you. You'll also hear from lawyers on behalf of the family core participants about this. For present purposes, I'd like to address 2 points in relation to the data that has been provided so far. Firstly, requests for extensions of time to provide finalised evidence. Secondly, the limitations to the data that has so far been provided by some of the providers. EPUT and Priory provided disclosure data in time for their evidence to be considered within this hearing. Signet Healthcare and St Andrews Healthcare requested deadline extensions from the 25th of February to the 28th of March. The inquiry granted these extensions, and it's therefore not been possible to consider information from these sources for the purpose of counsel to the inquiry's paper. Their responses in relation to ligature and absconsion incident data were both received by the 28th of March. Both EPUT and Priory acknowledge that there are limitations to the data they have provided so far. In short, searches in relation to relevant incidents are ongoing, particularly in relation to hard copy documents and where manual searches of documents and entries are required. It has therefore been impossible for the inquiry to come to any meaningful conclusions at this stage. There have been challenges in comparing the data provided by EPUT and Priory, including that they do not use the same definitions of key terms, such as absconsions. Following liaison between Priory and the inquiry, we confirmed the absconsion definition that should be used. Priory, in fact, went on to apply a different definition. It therefore appears to the inquiry that within the data so far provided by Priory, they have underreported the number of absconsion incidents. Chair, upon receipt of limited and incomplete data, the inquiry originally intended to publish snapshots of that data within the CTI papers, making it clear that no firm conclusions can be drawn from the data at this stage. However, the inquiry has taken on board comments from some core participants regarding concerns that this incomplete data should not be presented at the inquiry, and as such has redacted any reference to any figures from the CTI papers on ligature and absconsion data and the accompanying PowerPoint and oral presentation. The inquiry will consider analysis of the data once it is as complete as it can be. Analysis will be conducted if it's deemed appropriate and likely to assist in fulfilling the inquiry's terms of reference. Chair, the ligature and absconsion data papers conclude by setting out suggested next steps to the inquiry. This includes any clarifications that are required and potential further lines of investigation that the inquiry may wish to consider, in line with the terms of reference and list of issues. Inquests, adverse findings, and prevention of future deaths reports is another area which will be summarised in a presentation by counsel to the inquiry, and about which, Chair, you'll hear from lawyers on behalf of the family court participants. The paper prepared by counsel to the inquiry provides a general overview of inquests and the coronial process. It is deliberately at a high level, consistent with the purpose of this introductory hearing. It then summarises the responses from EPUT and other providers in terms of their engagement with the inquest process. This includes their responses to coroner's conclusions, including whether there have been findings of neglect, and the receipt of and response to prevention of future death reports issued by the coroner. I will refer to those as PFD reports. Some of the key points arising from the paper, which will be given by Charlotte Godber of the CTI team, include that the inquiry has so far received only some of the information that we would expect to be available about inquests carried out during the relevant period. This information does not appear to have been comprehensively collated and monitored. I'll return to that point in a moment. From the current data, we know, for example, that looking at the most recent statistics available, in 2023, over a third of deaths that occurred in England and Wales were referred to the coroner. Of those, 20% were deemed to require an inquest. That amounts to nearly 37,000 inquests opened in 2023, 492 of which followed deaths that occurred in state detention, which includes individuals compulsorily detained by a public authority. and that includes hospitals, where the deceased person was detained under mental health legislation, and instances where the deceased person was on a period of formal leave. Further statistical analysis will be carried out on this data, but first the inquiry will need to be satisfied that all efforts have been exhausted by EPUT and the other providers to locate all relevant information. Record keeping is an ongoing theme in this inquiry. It is featured in the responses from some providers in respect of locating PFD reports issued to their organisations and locating them within their own records. It may be significant that logging and retaining reports that were written and issued with the sole purpose of preventing future deaths does not, at the moment, appear to have been a priority for some providers. The inquiry is concerned that not enough was being done to monitor PFD reports. The concerns raised and the changes required, both within the providers concerned and more widely. This may again point to a gap in the regulatory framework. The inquiry will also be hearing from Deborah Coles, the Executive Director of the charity and NGO Inquest. It was founded in 1981 with the aim of reducing and preventing state-related deaths. It provides support to bereaved people, as well as sharing experience and advice with lawyers, support agencies, the media, and parliamentarians. Inquest's specialist casework includes deaths in police and prison custody, immigration detention, and mental health settings. Ms. Coles will talk about the stark difference in state monitoring of deaths in prison and police custody compared to mental health deaths. There is no central, comprehensive source of authoritative data of either mental health inpatient deaths or the deaths of those who have died in the community following contact with or under the care of mental health services. Ms. Coles refers also to the significant problems with investigatory processes where they relate to people who have died in mental health detention. Inquest takes on cases across England and Wales. Since 1981, they've worked on 1,843 mental health-related cases. 39 of these were connected to Essex trusts, and Inquest has determined that a number of those fall within the inquiry's terms of reference. It's notable that Ms. Coles says in her statement that nowhere has the effect of institutional defensiveness on patient safety been more clearly illustrated than in Essex. Chair, the inquiry has the King's Fund presentation, which I've mentioned already, and it covers the national legislative and regulatory landscape for the provision of NHS mental health inpatient care during the relevant period. We will also be hearing about relevant local structures and services in Essex. This is another of the sections of the evidence that will be summarised for you in a presentation by counsel to the inquiry, and about which you will hear from lawyers on behalf of the family call participants. The CTI presentation will be given by CTI member Dr. Tabo Elozue, and it will provide an overview of what the inquiry has learned from the evidence that we've received so far about the type of mental health services that were delivered to inpatients under the care of the Essex NHS trusts, the locations where those services were delivered, and the providers that were responsible for delivering them. The inquiry's terms of reference are focused on the inpatient care delivered by NHS trusts in Essex. We already knew those trusts included EPUT and NELFT. We have learned that it also includes Hertfordshire Partnership University NHS Foundation Trust. I'll refer to it as HPFT, which has operated specialist inpatient and community learning disability services in North Essex since 2010. This included an inpatient unit in Colchester called Lexton Hospital. The predecessors and previous names of these three trusts are identified in the evidence we have received and will be set out in the presentation. The only NHS trusts with inpatient mental health facilities in Essex by the end of the relevant period, so by the end of 2023, were EPERT and HPFT. However, the inquiry must look beyond the inpatient services provided by the Essex NHS trusts. There are elements of the definition of inpatient death in the explanatory note on the terms of reference, which make clear that the scope of the investigation extends beyond them. It encompasses NHS-funded inpatient mental health services delivered by independent providers and by NHS trusts outside Essex, as well as to certain outpatient mental health services provided by the Essex trusts. To date, the inquiry has sent Rule 9 requests for information to 46 different organisations to try to identify all of these services. The recipients include NHS trusts and independent providers from all over the country. We also requested information from the commissioners of NHS services, NHS England, and the Essex Integrated Care Boards. The information obtained has been analysed so that an overview of the data can be presented in an accessible form. The presentation will identify 34 different inpatient facilities and 120 different wards in which inpatient mental health services have been delivered within Essex during the relevant period. It will show how these changed over time, rising to a peak of 27 facilities in 2009 and then reducing to 16 in the final 5 years of that period. And Amanda, would you put up the Essex facilities video at the beginning and pause after 1 second? This map shows the location of those 16 facilities across Essex by the end of the relevant period. As we can see, they were in the following towns and cities: Colchester in the north, Clacton-on-Sea by the coast, Chelmsford in the centre of the county, Harlow and Epping in the west, and further south, Billericay and Wickford, then Rochford, Basildon and Grays. Would you now continue the video and pause it at the end? What we can see now with these bar charts are the mental health services delivered in each of those facilities by the end of the relevant period. The evidence that we have obtained shows that these are the mental health specialities or bed types that were provided by Essex NHS trusts throughout the relevant period. Adult mental health, long and short stay. Older mental health, long and short stay. Mental health assessment unit. Adult psychiatric intensive care unit. CAMS, or child and adolescent mental health services. Forensic, low secure. Forensic, medium secure. Learning disability. Additional bed types which have been added more recently are a mother and baby unit in 2010, a CAMS psychiatric intensive care unit in 2012, and a drug and alcohol detox unit in 2022. On the map, some of these services have been grouped together. For example, adult mental health with adult psychiatric intensive care unit, PICU, as shown on the legend, to make the charts easier to read. The height of the bars reflects the number of beds for each service at each location. The presentation will show how provision of these services across the Essex facilities varied through the relevant period. It will also outline the relevant non-inpatient services that the Essex Trust have informed us about. Thank you. Would you take that down, please? some key specialised inpatient services which have never been delivered by the Essex NHS trusts at any time during the relevant period are specialist eating disorder services, personality disorder services, and high secure forensic services. Essex patients have had to be placed with either independent providers or with NHS trusts outside Essex if they required these services. Other reasons for such placements included a lack of capacity in Essex Trust facilities, or if patients presented to mental health services as an emergency whilst away from home. The current evidence indicates that Essex NHS patients were admitted into 215 different non-Essex NHS facilities spread across the country over the relevant period. As the presentation will explain, this evidence is currently incomplete, so this is very likely to be an underestimate. And Amanda, would you put up the whole country facilities video, please? We can see here a map showing the postcode location and unitary authority region for those 215 mental health facilities alongside the 34 NHS facilities in Essex. Could you take the slide down, please? At the moment, the evidence we've received is not sufficient to reach any conclusions about whether and to what extent these placements were appropriate. As part of the inquiry's ongoing work, we will obtain as complete a record about all the providers and services as possible and enlist the assistance of the inquiry's expert health statistician to complete the analysis. This will provide important context to the care received by those within scope of the inquiry's investigations. Moreover, each of the providers will be asked to provide information about any deaths in scope of the inquiry's investigations amongst the patients they treated. Finally, the data may also be used to inform selection of other areas of the country to compare with Essex. Chair, those slides will be part of the papers of Dr. Elozue's presentation and will become available via the inquiry's website. We'll then, Chair, move on to expert evidence obtained by the inquiry. The evidence of Dr. Davidson and Ms. Nelligan seeks to capture the practical considerations of providing mental health inpatient care during the relevant period from a psychiatric and mental health nursing perspective. Whilst both experts approach their evidence through the lens of their respective profession, their reports substantially overlap, and for that reason their evidence will be heard together. Necessarily, both reports are high level and serve as no more than an introduction. Further, there are some areas which are simply too large to incorporate at this stage. One of these is neurodiversity, and an expert will be instructed to prepare a standalone report for consideration at a future hearing on neurodiversity. The Davidson and Nelligan expert evidence gives an overview of what happens when an individual becomes an inpatient and focuses on what good care should look like, where there is a significant degree of consensus within the professions. Given that their reports are addressed at a national level over a 24-year period, they do not seek to explain or apply standards to every aspect of care which they comment on. What falls below the appropriate standard can only properly be explored on a fact-specific basis within its full context. That type of assessment is not the purpose of this evidence. Their evidence is intended to bridge the gap between written policies and standards and what was happening in practice. In doing so, it seeks to draw out some of the challenges of working within mental health inpatient care. This evidence should be considered alongside the background presentations provided by the King's Fund and the National Collaborating Centre for Mental Health, which I've referred to. Dr. Davidson begins his report by highlighting the move in the early 2000s from the general psychiatry model to new specialities and the abolition of the one local mental health team model. He notes that there was a significant increase in numbers accessing mental health services by 2023 compared to 2000. During this period, there was fragmentation of services between inpatient and community care and treatment, meaning that care could lack continuity and joined-up planning. One common issue was waiting too long before admitting a person in crisis as an inpatient. Dr. Davison and Ms. Nelligan explain the balance to be struck between reducing the risk of harm and therapeutic intervention to remote recovery. In Dr. Davidson's view, at times, a focus on risk management dominated over the provision of effective care and treatment. He describes how, despite use of more restrictive practices, available information does not suggest that these resulted in a decline in suicide rates. Dr. Davidson also points out that in decisions concerning discharge and leave, there would be no entirely harm-free or safe options. Ms. Nelligan explains the pressure to manage risk of harm within a least restrictive practice framework. She shares Dr. Davidson's view that no environment can be risk-free, and any environmental modifications cannot be a substitute for therapeutic interventions and engagement from the nursing team. Over the relevant period, registered nurses had less time to complete psychological and nursing interventions with patients. This was due to the demands of the ward, shortage of registered nurses, and the increasing requirement to utilise a variety of IT systems to record various information. In addressing incidents requiring review, Dr. Davidson stresses the importance of looking not just at the actions of the last treating clinician, but of understanding their wider context and relevant systemic factors. At the same time as obtaining evidence from Dr. Davidson and Ms. Nelligan, the inquiry also sought evidence from the main providers of mental health inpatient care in Essex. In the same way as Dr. Davidson and Ms. Nelligan were asked to explain the process from assessment through to discharge during the relevant period, the providers were also asked via Rule 9 requests to set out how care had been provided. Given the inquiry's terms of reference span a period of 24 years, and there have been considerable changes over this period of time, this was no small task. The inquiry has received information back from some, but not all of the providers. The inquiry will hear oral evidence about these matters from Dr. Milind Kurele, the Chief Medical Officer at EPUT. Other evidence received will be summarised as appropriate. EPUT and NELFT were asked to identify and characterise the different types of mental health assessments carried out on patients under their care, which may have resulted in admission to an inpatient facility. The request required the providers to identify the key distinguishing features of each type of assessment and the key features they had in common. Particular emphasis was placed on eliciting how and to what extent a patient's personal circumstances needed to be considered when undertaking the assessments. The providers were also asked to describe the pathways by which admission could occur following assessments, the environments in which the assessments took place, and how they monitored and evaluated their assessment processes. Dr. Corrale's witness statement sets out a clinical overview of assessments, describes the evolution of assessments over the relevant period, and outlines general features of the assessment process. The statement then gives some specific detail about 10 different types of assessment: initial assessments, clinical risk assessments, gatekeeping assessments, Mental Health Act assessments, diagnostic assessments, memory assessments, assessments of neurodivergence, forensic assessments, eating disorder assessments, and psychological assessments. These matters will be explored with Dr. Corrale in his oral evidence. The inquiry's request for information from those providing mental health inpatient care in Essex extended to the inpatient pathway. The inquiry sought a broad explanation of the systems and processes involved in providing mental health inpatient care over the relevant period, from admission right through to discharge. The aim of the inquiry's requests at this stage was to obtain an overview of how those systems and processes were designed and intended to function, rather than to obtain details about specific incidents. The inquiry asked for information about the arrangements in different settings and whether or not there were particular units which had substantially different systems in place. The inquiry also asked for an explanation of the guidance, policies, operational guidelines, etc., in place at the relevant times, and we'll hear from Dr. Corrale about this. We were particularly interested to learn how and to what extent assessments and other decision-making processes were tailored to accommodate diverse patient needs, including adjustments for language, cultural considerations, and specific characteristics such as neurodiversity or physical or cognitive disabilities. In summary, as part of this request, the inquiry asked a number of questions about the following topics and issues, amongst others: assessments at the time of admission and ongoing assessments on the ward, decision-making, diagnoses and comorbidities, patients' interactions with staff, treatment, including medication versus psychological treatment, observations, coercive treatment and restrictive practices, opportunities for recreation and arrangements for leave, transfers to other units and providers, engagement with other agencies, involvement of the patient and their support network in decision-making, planning and care, the multidisciplinary team, the MDT, and second opinions, record keeping, monitoring, and raising concerns. Another area of particular interest is the question of how risk management was and is balanced with therapeutic care. We're keen to understand how potential tensions are resolved between the objective of protecting a patient from harm and the objective of improving their clinical condition. This will be one of the matters we continue to look at very carefully. As I've mentioned, during the course of this hearing, we will hear evidence in relation to the use of vision-based digital observation technology. This will include Oxyvision, CCTV, and body-worn footage, although the focus in this hearing will be evidence relating to Oxyvision. We will hear from witnesses from Oxy Health, the provider of the technology itself, from ePut, and from the national campaign Stop Oxyvision. Oxy Health is a health technology company and the manufacturer of Oxyvision. Laura Cousins is the head of patient safety and quality at Oxy Health Limited and has provided a statement. She gives evidence about how the technology works in practice and its various functionalities and the evidence base that demonstrates its value. She furthermore sets out its collaboration with and consideration of guidance from other organisations, such as the National Mental Health and Learning Disabilities Nurse Directors Forum, NHS England, and Rethink, to support the care and treatment of mental health patients. Oxy Health and ePut have been in discussion since 2019, and the technology has been rolled out amongst ePut wards since April 2020. We understand it has been deployed across half of all NHS trusts, and during the relevant period was live in at least 29 ePut wards. We will then hear from Zephan Trent, who will give evidence about the use of this technology from EPUT's perspective. He discusses the basis upon which Oxyvision was introduced and how it was implemented. He provides the Trust's standard operating procedure for Oxyvision and sets out the Trust's position on the consent process for Oxyvision specifically. He confirms that there is an ongoing review into the use of Oxyvision to ensure the Trust has considered the matters raised in NHS England's February 2025 Principles for Using Digital Technologies in Mental Health Inpatient Treatment and Care report. He sets out how EPUT evaluated the use of Oxyvision, including by way of patient feedback and also independent studies of its vision-based patient monitoring system. Finally, on this topic, you'll hear evidence from Hat Porter, a representative of Stop Oxyvision. This is a network of former and current NHS patients who, in spring 2023, founded this national campaign to raise awareness of the serious harms it suggested the technology has caused across England. Stop Oxyvision has analysed research and collated an evidence base of individuals' first-hand experience of the technology and raises key concerns with its use. Among these, it refers to significant invasion of the privacy of patients, the impact of the technology on the patient's health and recovery, and staffing issues, describing it as a superficial quick fix for wider systemic issues. Stop Oxyvision is also concerned about the lack of oversight and the risk of discrimination in the use of this technology. Hat Porter describes many patients' experiences of the technology as being intrusive, undignified, dehumanizing, and traumatizing, and suggests there's a lack of transparency about the technology's use. As I have already said, we will also be hearing from the CEO of EPUT, Paul Scott. He will be asked questions arising from the position statement provided on behalf of his organisation. He will not be asked about other matters at this hearing, but he will be invited back to a future hearing when we will have received and heard more evidence and when questions can be directed at more specific and substantive issues. The request issued by the inquiry to EPUT sought a broad, candid narrative providing the Trust's own accounts of events, which acknowledged where things went wrong and explained why those failures occurred. The inquiry made clear that the position statement should reflect the Trust's duty of candour and stated commitment to supporting the inquiry in delivering answers to patients, families and carers, and that they should not simply restate policies or past submissions, but instead offer a clear-eyed assessment of what happened, what went wrong, and what has or has not changed as a result. EPUT was also asked to address a number of specific areas linked to the inquiry's terms of reference, namely EPUT's role and responsibilities, patient care and safety, patient and family engagement, staff management and conduct, leadership, government and culture, incident investigations and responses, and data management and record-keeping practices. Mr. Scott addresses each of the areas I've just outlined. His approach overall is perhaps best summarised by his explanation that, since its creation in 2017, EPUT has focused on efforts to improve care for patients. Much has been achieved, but I also recognise that much remains to be done to improve mental health services and the work to create a single trust from NEP and SEPT, providing safe and effective care across all of its services, has been challenging. We will hear more from Mr. Scott about this and about the EPUT position statement generally. Chair, before I move on to future hearings and further observations, I'd like to make reference to the inquiry's engagement with mental health charities. So far, the inquiry has obtained statements and information from a number of charities, including Mind and Rethink Mental Illness, whose statements appear in the bundle for this hearing. The statements summarise the charities' purposes and their involvement in inpatient care generally, and more specifically, their involvement with Essex-based trusts. The inquiry has also received information and evidence from charities such as Healthwatch Essex and Autism Action. Their evidence will feature in future hearings. Moving on. Preparations are underway for the next hearing, which runs from the 7th to the 24th of July. The July hearing will include evidence from family members related to the circumstances of those who died whilst under the care of SEPT and NEPT. We will provide further information about the July hearing after the conclusion of this hearing. Chair, it's clear that serious issues with mental health care in Essex continue, which underlines the significance and urgency of the work of the inquiry. The Secretary of State for Health and Social Care announced a series of investigations into mental health inpatient settings in June 2023. These investigations launched in January 2024 and concluded in January this year. They were conducted by the Health Services Safety Investigations Body, HSIB, and appear to be directly relevant to the work of this inquiry. HSIB investigates patient safety concerns across the NHS in England and in independent healthcare settings where safety learning could also help to improve NHS care. And we saw HSIB on one of the King's Fund slides earlier. It carried out 4 directed investigations under the mental health inpatient settings theme. One, creating conditions for the delivery of safe and therapeutic care to adults in mental health inpatient settings, which was published in January this year. Out-of-area placements, published in November last year. Supporting safe care during the transition from inpatient children and young people's mental health services to adult mental health services, published in December last year. And creating conditions for learning from deaths in mental health inpatient services and when patients die within 30 days of discharge, which was published in January this year. Across the 4 investigation reports, HSIB issued 17 safety recommendations to national bodies. They also made 23 safety observations and included specific learning points for mental health providers and integrated care boards to encourage improvement across health and care locally, regionally and nationally. In summarising their findings, HSIB state that across all 4 investigations, it was clear that patients and families often felt their voice was not heard and that they were not involved in crucial decision-making about care. The reports emphasised that lack of patient and family involvement often contributes to psychological and physical harm. Patients are regularly cared for in environments which are deemed not to be therapeutic and do not meet their needs. Collaboration between services was found to be an ongoing concern. The inquiry notes the findings of HSIB, which are on a national basis, and will be considering these reports as part of its own investigations. Chair, it was only last month that the area coroner for Essex issued a prevention of future deaths report to EPUT that is also of considerable relevance to the inquiry. This was in relation to a tragic death towards the end of 2023. It followed an inquest in which the coroner recorded that the deceased took their own life in the context of multiple failures in the care, management and treatment provided to them by EPUT, and that those serious failings amounted to neglect. The Prevention of Future Death report listed failures in care planning, documentation, risk assessments, the allocation of a care coordinator, communication, and discharge planning and execution. an inquest into a further relevant and equally tragic death that also occurred in 2023 concluded last month with a further finding of neglect. The coroner found that the deceased's deteriorating mental health, that included recent overdose, suicidal thoughts and plans, remained untreated. The deceased had made multiple contacts requesting a review in the 2 months prior to their death and did not have the required mental health risk assessments or a medication review, and the coroner found this contributed to their death by neglect. These are all issues that the inquiry is investigating to varying degrees. And worryingly, there are other relevant recent inquests in which there have been findings of neglect. Furthermore, the inquiry is aware of deaths occurring in 2024 and even this year, which appear to raise similar issues. Chair, the inquiry was deeply sad to note a death as recently as last Tuesday, the 22nd of April. The inquiry's terms of reference relate to deaths taking place up to the end of 2023. But, Chair, I would suggest that these further tragic deaths after that time are relevant in this way. They may point to serious and ongoing issues in Essex. This in turn may be relevant when you consider the success of the steps that the Trust has taken to improve services and also in the framing of your recommendations. The inquiry will therefore continue to monitor these further deaths with care, insofar as they are relevant to the terms of reference. Chair, I'm coming now to the end of my opening statement. In doing so, I'd like briefly to consider the changing mental health landscape, and we're certainly entering a period of change. And I'd like to give 3 examples of what I mean. First, in October last year, the government announced the development of a 10-year health plan for England. It is to reform the health system and will be structured around 3 shifts. These shifts are moving care from hospitals to communities, making better use of technology, which will include digital transformation, and focusing on preventing sickness, not just treating it. These may have major implications for the delivery of mental health services in Essex and nationally. Second, the Mental Health Bill, which was introduced in the House of Lords in November last year with the aim of modernising mental health legislation to give patients greater choice, autonomy, enhanced rights and support, and to ensure everyone is treated with dignity and respect throughout treatment. The bill is intended to give effect to the policy outlined in Sir Simon Wesley's independent review of 2018. The review set out 4 guiding principles. These are choice and autonomy, that is respecting people's views and choices by listening to what they want in their mental health care. Least restriction, that is limiting freedom as little as possible and using the law appropriately to prevent people being detained if they do not need to be. Therapeutic benefit, that is giving people the help they need to feel better and helping them get the right treatment. And the person as an individual, that is treating patients with the respect and understanding that they need. Again, these are all areas of interest to the inquiry, and we will monitor the bill's passage through Parliament. And thirdly, there is the announcement last month that NHS England will be abolished. Many of its current functions will be returned to the DHSC, and there will be a longer-term programme to bring NHS England back into the department. NHS England and DHSC are, of course, both core participants in this inquiry. Which brings me back to the importance of the Recommendations and Implementation Forum. Chair, you'll wish to understand the environment into which your recommendations will be delivered. And that means taking account of important changes that have been announced or are underway. This will be part of the forum's role. In order to make recommendations that land well and are implemented, the inquiry will wish to work with our core participants and key stakeholders. That will be whether they are health or other bodies, or the individuals who have been so badly affected by the matters into which the inquiry is looking. I'm at the end of my opening remarks. A written version of this opening statement will be available on the website, containing links to the documents that I've referred to. We will be covering a wide range of evidence and issues at this introductory hearing. This will clearly show the extensive work that the inquiry is undertaking. And this is just the beginning, Chair. Working with the inquiry's core participants and others, you are determined to make appropriate findings of fact, to ensure accountability, and to make robust recommendations for change where necessary. The inquiry continues to meet with its family core participants, and I'd like to end with the words of two people I met last week. They spoke courageously and compellingly about pain, hope, and change. Pain in the loss of family members they adored, and pain afterwards, in their words, when they were treated disgracefully, brushed under the carpet, and when they and their loved ones were shown an utter lack of respect. Hope now in the knowledge that they are not alone and that they are being listened to. Hope too that their loss has not been in vain and that others will not need to go through what they have. And change that will spring from hope, real and lasting change in honour of those who died. Chair, that's the end of my opening remarks, and that brings us to an end of today's proceedings. We will start again tomorrow at 10 a.m. when the inquiry will be showing the documentary Dispatches, Hospital Undercover, Are They Safe?, which I mentioned earlier. We'll then hear a summary of some important evidence before we hear from our first witness, Jane Lassie from the Health and Safety Executive. So, Chair, that is an end of today, and we start again tomorrow at 10.
Thank you very much indeed, Mr. Griffin. Until 10 o'clock tomorrow.